future is far off. So in the interim, and it's very messy right now, and some people have referred to it as something like the chaotic middle, we have this point where the cars are undoubtedly computers. 100% of all cars being introduced into the marketplace today have some level of automation, and they all have 5G modems embedded in those cars, beaming data from the car to the cloud, especially after an accident. And that was very important in this case. I'm going to talk first, though, about the trial as a trial. And one of the things you experience, Phil's testified several times in trials. So while he's not a lawyer, he's about as experienced and expert in legal proceedings as one can be. The problem in a trial that lawyers always have to work around is they're not allowed to get into some areas. And so, in essence, there's a story about what happened that is not really the whole story the jury gets to hear. And that's a creation of the law. So sometimes there could be information that's prejudicial. And an example of that is the National Transportation Safety Board has done investigations of Tesla in the past and have made recommendations to Tesla. But that report was not allowed into evidence. And I don't want to get into the why of that. That could take an hour as well. But it's things like that that courts weigh whether or not that's really the right way to treat the parties in the litigation. So,
Mike, if I can, let me tell
yeah.
the substance, because the substance is so relevant. What NTSB did as a result of, I think it was the first Tesla fatality, is they made two recommendations saying, hey, you really ought to automatically enforce your operational design domain. If you're on a road with crossroads and intersections, which you're not supposed to be driving on, the computer should not allow itself to be turned on. That was NTSB recommendation number one. Number two was, hey, this steering wheel torque monitoring, that's not an effective driver monitor. You need an effective driver monitor. And that was years and years before this crash happened. So for someone with a research training, man, that sounds really relevant to me. But what you're saying is, for legal reasons, nobody could tell the jury that NTSB had figured this out years before the crash. I just want to make it really concrete that this isn't hypothetical. This is from a I want to understand the truth and the facts. It's incredibly relevant, but the jury never got to hear it.
Yeah, so you referred to steering wheel torque monitoring. I'm going to say it slightly differently. So some car manufacturers have a driver monitoring system. How do we make sure the driver's paying attention? And so some manufacturers, and I'll start off with General Motors and Ford, worked hard to build camera-focused driver monitoring systems. Was the driver paying attention down the road? Tesla and other companies like Rivian, they started off with a driver monitoring system that is called a haptic control, where you have to hold on to the wheel, but you could be looking out the window. You could be hanging your head out the window. And as long as you were holding onto that wheel, the car was satisfied that you were monitoring the roadway as a driver. And obviously my examples show how silly that can be, and it's also subject to abuse. So it seems like there's no perfect system, but a system that has both of those would be good. But I want to get back to this case because we have a Tesla that had a driver monitoring system, which was touching the wheel. And again, NTSB had recommended that Tesla do something better or different than just simply touching the steering wheels. Did I get the essence of what you were talking about,
Yeah,
Phil?
that's right. Yeah. So well, in this case, what we had was the core of it was that the driver dropped his cell phone and was looking around the footwell for a cell phone. And while he was doing that, the Tesla Autopilot remained engaged despite two things. The first thing was it remained engaged even though the driver was clearly not paying attention to the roadway. And it remained engaged even though it was on a roadway with a T intersection, which it should not have been engaged on because it's not designed to be used there. And so both of the NTSB recommendations years earlier had said, guys, you got to do better. And they didn't hear about that.
the important thing, especially on the latter part, is the T intersection. The car can see that it's a T intersection, and yet it didn't do what you would expect it to do, which is um, do something about the fact the road was ending. And instead, the car went right through the end of the T intersection.
Like warn the driver or slow down or decide to turn or something.
Right. But I mean, clearly the car knows, especially since it has mapping capabilities. And we were talking about that um, earlier this week, Phil. Um, how helpful or how important is it that the car be attuned to all the elements in its environment so that it can perform the safety task? I mean, the safety components of driving safely.
Well, in order to drive safely in an environment like that, it has to know a lot. It has to be able to see the intersection, has to be able to see the signs, make the turns. But in this case, all it really had to do for safety, because there's can you drive effectively and there's can you be safe? To be safe, all it had to do was say, hey, I'm on a road that violates my operational limits because it has an intersection. Driver, you got to take over. I'm sounding the alarm. But it didn't do that. It just kept driving. And there's another piece, I don't know if you're going to get to it, but it flows right here, which is there was also a National Highway Traffic Safety Administration. It's a recall for Autopilot. And two elements of the recall were, hey, you have to enforce the operational design domain, and hey, you have to do better driver monitoring. And that recall also came out before the crash. And I'll let you tell the legal parts, but also that was an issue about whether the jury knew about that. I think that was a little trickier.
Well, and it's always a question as to what does the jury know? Does the jury know anything prior to? Are they self-educating, which they're not supposed to during the trial? So again, those are the things that there it's supposed to be a very
But they weren't supposed to, they weren't, people were not allowed to testify about that recall, were they?
no,
Yeah,
no, they
okay,
could
so
they were allowed to refer to the record of that kind of thing happening, but only from the standpoint of feasibility. And again, these are sort of the legal rules. Was it feasible to do what the recall wanted?
So, assuming the jury didn't know anything coming in, they didn't know that NTSB had recommended years earlier this be improved. They did not know that NHTSA and Tesla had negotiated a recall where Tesla admitted they, that they could improve and said, "Look, we improved." But the takeaway, I think there was a stipulation in there. The takeaway, the only thing jury heard was, yes, Tesla is going to admit that we could have done better, so we don't have to tell the jury that, we got whacked on the snout with a safety recall and these other things. I think that's where it ended up. So
Yeah,
the
that's
jury
exactly.
doesn't know what we know, and it's important to remember that when you see a trial.
Yeah, Tesla admitted the feasibility prior to 2019 that it could have implemented stronger DMS alerts and also visual prompts and roadway checks and autopilot suspensions. Those were the parts of the stipulation.
Which is what they did in the recall, and they could have done it earlier. Obviously, they could have, right? So
Right.
instead of bringing up the recall, they just made that omission and they set it aside and said, okay, we're done, move
Yeah.
on.
I'm going to just move a little bit more towards the geeky side of this case, if this is not already geeky enough. But we're going to talk about the Tesla systems and the data. And I'm just going to get into this a little bit and then like to get your thoughts. But I mean, when you hear the reporting of this, you can certainly get a sense of that being an issue. But there's a whole vocabulary of data, systems, and it's what normal people really wouldn't be able to comprehend. But if keep in mind that what we're talking about is a robot, certainly you're going to expect those kinds of dynamics going on. And uh, but I'll start off with one of the legal duties a party has to, or several legal duties show up in this trial record. And we should point out, while we already talked about this a bit, it was from what we were reading in the press and what we told the audience last time. Let us get into the transcript. Let us get into the exhibits. Let's really get to the facts that went into the trial. And what did the jury think? What was the jury asked to consider? And so there's this one story that bears worth mentioning, and you have to understand how Teslas operate. They are tracking data all the time, even without an accident. And what they're doing is that data is being beamed from the car to a cloud. That's why it has a modem. And it's using that data to self-educate, to tune the robot, to tune its machine learning algorithms. And it's doing a very simple task too. It's saying, oh, Phil he rolled through that stop sign. We really should stop at stop signs. And it's comparing human behavior to what the robot thinks should be done. So after an accident like this, you can imagine that data is now even more special because it's a real life problem, or as engineers call an edge case. And uh, a bunch of data gets beamed up to the cloud, the Tesla cloud. And then this didn't always happen, but now Tesla will then disconnect the car from the cloud, and basically the car, the data in the car is no longer that accessible. But Tesla has that data.
Yeah, so I
And
can be quite precise. If there's been a crash event, some
yes,
sort of crash alert, which airbag deployed, high G, something like this. Tesla, there's software in the Tesla that if, well, going back, it collects data. I've seen the data collected, and it was from the day the car was sold, and it's all in there somewhere. They used to use an SD card. I think the hardware's changed since then, but all the data is there since the day the car was sold. And but in the event of a crash, it goes back a while, a few seconds, and says, all right, I was just in a crash event. I'm going to collect up all the recent data from my logs. I'm going to package it up in a compressed file, or in a file, in an archive file. And I'm going to beam that archive file up to the Tesla cloud. And when the Tesla cloud acknowledges it received it, I'm going to delete my local copy of the archive file. I'm not going to delete the underlying data logs. I'm just going to delete the temporary file that beamed up. And I only do that if I know that the cloud has said, yep, I got it. You can delete it. So that's how it works.
yeah, I've actually deposed Tesla engineers, and they tell me that the entire data collection in the car is beamed up after an event. I think there's two events. They would an airbag deployment,
Well,
or wake up.
when they say entire, I don't know if they mean 5 years worth. I think they mean a little bit less, because
Yeah.
but we'll, it could be that the entire thing is beamed up and Tesla only produces some of it when you ask. But be that as it may, for sure, the history for that entire drive cycle is going to be up on the cloud for sure.
And then what happened here is a bit curious. So the law enforcement gets involved because there's a fatality and another serious injury. And they go to Tesla and say, okay, we'd like the data. We want to send you a subpoena. And someone at Tesla, and I'm not going to bring up any names, but someone I've dealt with a lot, um, says to the police officer, this is really complicated. I'll draft the wording you should send me, but don't send me in a subpoena. Just send it to me in a letter. And so the police officer does exactly that.
That was a mistake for people keeping score at home. That was a mistake.
That is a mistake.
Yes.
Um, and um, and on top of that,
Actually, so why was it a mistake? Because Tesla has a lot to lose and a lot to gain. So you're
and
asking a party who's motivated to act in certain ways to do your job for you, and guess what? Their thumb's going to be on the scale.
and I can tell you from personal experience that the data that you get from Tesla, which they call consumer data, this is what consumers can now request on an app, um, is just a fraction of the
It,
data that Tesla
it's not
has.
all the data for sure. I've done the side-by-side comparison. It's not all the data, not by a long
Right.
shot. And I don't
So
mean in time. I mean, for whatever happened in that 10
the
seconds.
scope, yeah,
If you
the
go to
scope
the
of the data.
car, there's a whole lot more data in there, more entries, more frequency, more stuff than what you'll get from Tesla, for
Yeah, so
sure.
you really have to know how to ask for it and not be coached by Tesla how to ask for it. So, um, so it became a, a mystery about, well, where's all the data? And Tesla said, we didn't keep it all. That was their first response and discovery. So plaintiffs hired a few experts to go into the vehicle and grab the data that supposedly no longer existed. And they found the data that they were looking for.
So let me be precise. So they got this archive file beamed up and they said, well, we deleted the archive file. We just kept the consumer data. Is that what it amounts to?
I think so. It's hard for me to understand from this
It's kind of
record.
weird. In some tellings, it's like we didn't even get the archive file, and that doesn't make sense either. But okay.
Right. And I don't understand the full story even after looking at the record, but something like that happened.
Yeah.
And then
Or,
plaintiffs
oh,
counsel,
so plaintiffs accused Tesla of affirmatively deleting data. That was the accusation made.
yes. And Tesla admitted that they did delete data. But that was not, according to Tesla, intentional or specific to this case, but just the way the system works.
Yeah.
And lo and behold, when they did go to the car and harvest data out of the hard drives or just call them computers.
There's a flash memory drive of some sort.
Yeah. They were able to find more data in the data they were looking for. I'm talking about the plaintiffs.
Well, so for the folks who are really into it, the thing that was really interesting, of course, all the data is there. It's really painful to get out. But what they found was, so Tesla, I think, had claimed the data didn't get beamed up, right? They claimed, my memory is, they claimed, well, the data was never beamed up. But when they reverse engineered the hard drive, they found the bundle file, the tar file, and they found that it had been created and deleted. And the only way that would have happened is if Tesla had received it.
That's
And
right.
so they used the date timestamp from the record of the deleted file to tell Tesla, look harder, you have it. Here's where you're going to find it. And Tesla said, oh my goodness, we didn't know we had it. Look at that. There it is.
That's absolutely right. You used the term tar. Could
Yeah.
you explain what you mean by that?
It's a archive file. It's if you take if some folks know what zip files are, so it's sort of like a zip file, right? It's morally equivalent if you're in a Unix system. No point going further, but it's a whole bunch of stuff lumped into one file, like you would do with a zip file or some other bundled attachment.
So Tesla, and this did play out in front of the jury, and Tesla doesn't look good from the standpoint of being forthcoming.
Yeah, and they were saying, "Oh, we're so glad we got it. It was so helpful." And the jury's got to be sitting there saying, "Come on, guys, you expect us to believe that the most valuable tech company, or one of the most valuable tech companies in the world, I haven't checked the stock market later, one of the handful of most valuable tech companies in the world can't find a file when they know the day and time to look for? Are you kidding me? I mean, if I'm in the jury, of course, I'm not an average juror, but I got to be asking that question, right?"
Yeah, and I mean, obviously, there's a lot of Teslas out there, and there's a lot of data,
But they
and
knew when to look, and
but
they got
and
all these
the,
computers there to good at searching. Come on, right?
but the key was they didn't have the record, the identification number that the plaintiff ultimately got from the
Well,
car and said,
they,
"Here."
they shouldn't have needed that.
Yeah,
The identification number made it impossible for them to play dumb, is what it
right.
boils down to. Yeah.
Yeah.
Because if you don't look that hard, you might not find it. But the plaintiffs had such precise, here's the transaction number. How at given, of course, if you look for the transaction number in the data log in the database, you're going to find it.
And and some of this had to do with a Tesla employee, and his name is Michael Calafell, and I'm using his name because it's just in the record. So he admitted that he had prepared an affidavit. And an affidavit is a sworn statement. So there's a document that gets created. It's his sworn statement about various things. And he signed it. And it's considered testimony. You're representing to the court, this is what your testimony would be if called to testify. And he admitted that the affidavit was wrong, but it's easy to understand as a lawyer how this happens. This may be an innocent problem, or I suspect maybe not. So what he testified to is that the affidavit was created by the Tesla attorneys. Now, they don't have any specialized knowledge. They didn't have any firsthand knowledge. So they create this affidavit. Now, they probably did that by interviewing him. And then they probably thought, well, the story's going to sound a little bit better if we word it this way. But apparently, it was worded in a way that it was inaccurate and it was signed anyway. So,
And that can be tricky because as an expert witness, sometimes I would write my own reports anytime I could, but sometimes the attorneys would present something and say, this is what we want you to say. And they're very artful in their wording. They will say things that are misleading to readers while technically true. That's just like a lawyer writing skill, right? Because they're hired to make an argument for the client, and that's the job. It is what it is, right?
yeah.
But if you're an expert, if you agree with it, you're signing up to that potential misinterpretation, and you might get called out on it later. And the best case is he didn't realize that what he was signing could be misinterpreted so aggressively. That's the best case.
And he was
So
huge
if you're ever asked to sign one, read it as if someone's trying to tear you apart and change it.
well, and that's I want to make sure I never get into that bind. So
Yeah.
what I do is I always make sure that that affidavit is something I have a really good record of. I will sometimes, create it for experts,
Mm,
but it's taking their words, their specific words, putting
yeah.
in an affidavit so it flows well, and
Yeah.
then send it to them and say, okay, read this carefully because when you're asked, are these your words? Your answer has to be for your sake and for my sake that this is yours, not mine.
Yeah.
And I go over that
It,
in a very learned way.
the experts have to make sure the lawyers aren't putting words in their mouth because nothing good can come of that. But I've seen that a bunch of times. That happens all the time in
and,
practice.
and the other side of that coin is sometimes experts will take very strong positions in the beginning, and
Mhm.
then they'll say things to attorneys, and attorneys want to count on that position. And then for whatever reason, the expert gets cold feet. He may have
Yeah.
overstated his position, or he maybe didn't do enough work to study the case well enough.
Or he
And
discovered a new fact. That happens, right?
right,
Yeah.
but you know,
Yeah.
so we would refer to that as a witness going soft.
Yeah.
And so if an expert goes soft and his affidavit was firm,
Mhm.
and you counted it as a lawyer and you got a signed affidavit, don't blink. Well, so this happened in this case.
Yep.
So there's two of these things that the
And it
jury
looks and it
about.
looked really bad for Tesla. The fact
It,
it happened looked really
it
bad.
was, and it's a Tesla employee. It's not their
Yeah.
expert.
Yeah.
So, and this was the guy that had a large role in playing, working on the data problem that they were experiencing. So, we spent a lot of time talking about data, but I think it's an an important part of this trial.
Oh,
Let's
let me
maybe,
bring up one other thing the jury
yeah,
didn't hear about because it was too new. NHTSA is now investigating Tesla for delaying reporting of problems. So it smells like there's a much bigger data problem at Tesla than just this one trial. Now, if you're asking about the jury, it's not relevant because that happened after the trial. But if you're asking the what do we do about the next trial, guess what? This is gonna come into play.
yeah. And for you fellow geeks back home, we're talking about the standing general order reporting requirements. And but Phil and I have decided that there's going to be another session,
Oh,
not
a
so
whole
much
different discussion. Yeah.
not based really on Tesla. I'm sure Tesla's going
But
to be uttered in there, but just generally the problem with evolving EVs, or I'm sorry, EVs, and what are the engineering problems? What are the human problems? But we're not going to get too far into that right now. So let's talk about the human factors part of this, Phil, which I know is so important to you. It's really important to me. So, any observations from the trial record about the human factors at play here?
Well, it was kind of interesting that we saw that the driver was not paying attention, he admitted that, but we also saw that the driver responded as well as you could expect to what the system did. So the system sent the driver an alert. I think it was less than 2 seconds before crash. And the driver responded in, I think it was 1.1 seconds, which is really all you can ask. Somewhere a response that the car goes ding and you pay attention. 1 second, yeah, that's pretty good. You can't really bank on anything faster than that. So the car did warn the driver that something was going wrong, but it was already too late. But the other thing was the driver, they say the driver was distracted, but the driver was paying enough attention to respond to the driver alert warning. So what the driver said was, well, I was counting on the Tesla to let me know if I needed to pay attention. And what we know is consistent with that. Now you can say, well, the driver should have been paying attention. He should have known because we have these disclaimers in the manuals. But what also came out at trial was, all the autonomous washing that's going on. The driver's just there to keep those annoying lawyers happy. The car is driving itself, and you see that video. And what do you expect the non-technical average driver to do? Well, they keep hearing this car drives itself. Why would you expect them to believe anything except that? And so they're going to have trouble paying attention. It's not a lack of moral character when you can't pay attention. It's called being human. People can't pay attention when it's boring. That's just the way it goes.
So McGee, who was driving the Tesla and dropped the cell phone, um, he he reacted to an audible alert on average about 1.1 seconds.
Which is, 1 second plus or minus. That's all you can ask, right? That's
Right.
pretty good. So he was behaving well within human response time norms to the alert. What happened was the alert happened too late to prevent the crash. That's what happened.
Yeah. So, I mean, listen, dropping your cell phone and looking for it while you're driving on a road, I don't think anybody's going to think that's good behavior.
And the jury found him 2/3 guilty for that, and fair is fair, right?
But this was a fairly long ride, and he received a lot of different alerts. Some were called, in the record, I've never heard this term before, but toast pop-up warnings. And I know what they are. I've owned 3 of these Teslas. They flash on the screen. My first Tesla had a screen in front of me and in the middle. My 2 most recent Teslas have a screen in the middle only, and these things pop up and then they disappear. And there's wording, and sometimes there's several layers of these things that are popping up. And
by the way, that's a horrific design. So let me
yeah,
explain why.
yeah.
Okay, so you have text is harder. Text takes longer to look at, focus, read, process than an icon. The reason you use icons are like, oh, the icon, right? You train yourself to recognize the icon. But what you have is a system where there's a ding and you're trained to look at the center screen to see some text. And you're like, there's some text. What's the text say? It says, pay attention in the road. Oh, and 2-3 seconds have gone by where it's distracted you away from the road to look at the message telling you to look at the road. I mean, what are they thinking?
The most
Why would you build
dramatic.
it? That's ridiculous.
I was telling you the other day, it was only a couple hours of Tesla pilot experience, and
Yeah.
I had this amazing dramatic problem where the most severe thing it can do is say, take over, I can't do it.
Yeah.
Okay? And a red steering wheel shows up.
Yeah.
And so,
Well, the red steering wheel, so the red steering wheel icon, at least if you know that means take over, the cognitive processing time and the glance away, if that's in front of you, that's going to shave a couple seconds off the response. That's a good thing, right? But it is kind of generic, isn't it?
yeah, it really is. And
It
then,
amounts to you're going to die message. It's a you're going to die message, right? So
yeah,
yeah.
words don't happen. And oddly enough, this is a wonderful thing to read in the trial record. Um, what you get is a ding
Mhm.
or other chime is it's what it's
But
referred to
but that
as.
chime means more than one thing. It's not like
Chime means hey.
so that doesn't help. If it were a fire an air raid siren and the only thing it was used for is you have to look out the window, then people would train themselves, oh, that means look out the window. I don't have to read the stupid center console telling me to stop looking at the console and start looking at the window.
So picture you're in the courtroom, either as a jury member or sitting in the courtroom as an observer. There was a strong discussion about, was the chime being played at the appropriate level?
All right, so they played the chime in the courtroom.
Yeah.
And the problem is, was it too loud or too soft? And it's at the ears of the jurors when this is big room, right? But there's
Yeah.
also road noise. It could be just as loud, but you don't have road noise. So it's
It-
really hard to know. the only way to give a juror an experience is to put him in a moving car and play the ding. That's the only way. There's
Yeah.
nothing,
And in
everything
this
else is going to be
particular,
a mental experiment by jurors who don't have PhDs in acoustics and psychoacoustics, right? So that,
yeah, and the plaintiffs seem to
yeah,
be making the point. Yeah, you're saying the guy got warnings,
yeah.
but flashes on the screen, the warnings are layering over each other,
And a little
and there's,
ding, right?
and there's
Yeah.
dings and chings and
And
chimes.
but that's he actually responded to the warning in 1.1 seconds. That's all you could ask for. He didn't
Right.
ignore the warning. So in a way, it's a red herring. But there's this whole thing about how do you reproduce the in-vehicle experience at the time, and it's tricky.
Well, we get another 10 minutes before we open up to some questions.
Yeah,
I'm going to talk about punitive damage parts of this case.
yeah.
And then I'd like you to talk about just in general engineering and safety concepts
Mhm.
as that we're flowing out of this trial. Okay.
Mhm.
So I'm going to hit the punitive damages very quickly. And this has something to do with Tesla's post-trial motion. So, again, the compensatory damages, Tesla was found to be 33% liable. McGee was found to be 66% liable. That apportionment's going to be problems for everybody going forward. Like, how do you apportion fault between the driver and the car? Okay, but that's what they
Although
came.
that happens in traffic crashes all the time, so it's not weird for it to be a percentage.
Well, it's
On
not going to
insurance
be a
claims, there's
percentage.
like 25% subrogation and all these. So the fact it's a percentage isn't weird per se, but it's complicating, right?
It's complicated when you make it a human being and a machine,
Yeah,
you
right.
know, sharing that responsibility. But anyway, Tesla was found to be 33% responsible, and that's the 42 and change part of the $242 million verdict. But then they were hit with $200 million in punitive damages. And so in Tesla's post-trial filings that were made just a few days ago, um, they made this observation about, well, first they felt that the compensatory damages should be reduced dramatically.
Well, of course they're going to
Um,
say that, but that's
and yeah,
you know,
right.
they're
And
always going to say
I
that.
do
Yeah,
have to say that the jury did give a lot of money to the plaintiffs, and then it was cut in half or
yeah,
in a third, and it was still a lot of money.
yeah. That's
Um,
fair. That's fair.
uh,
Still a lot of money.
but then the $200 million that Tesla was hit as punitive damages, they they take the position that that violates Florida law, or at the most it should only be three times.
Yeah,
With
apparently there's a
compensatory damage.
multiplier you can multiply by three. I've seen those.
Yeah,
I did a trial in Oklahoma where it was 1-to-1 that they wanted the punitive damages to go to the moon, and they said nope, but we're limited by 1-to-1. So I get that.
yeah, and the Supreme Court actually is weighed on this pass, and they say, well, it should be in the single digits,
Yeah.
closer to 1-to-1,
Mhm.
but to pass constitutional smell test. But anyway, so they've made these requests to have the damages reduced, and we'll see if that works out. Um, but the engineering and safety concepts that you have already talked about a bit, but maybe talk about what those were in this case that really become very obvious when you look at the record of the trial.
Sure, sure. Let me weigh in on the punitive damages. So there's one of the post-trial motion things.
Phil wants to be a lawyer, everybody. So
Yeah,
he understands.
no, I don't. I've actively resisted. So, but because this has actually been in the news, that the Tesla is saying, well, the reason for punitive damages was they were upset that we hid data, allegedly hid data, right? But they weren't supposed to be told that we had data. And so the thing we already discussed about losing the file and was it on purpose and was it not on purpose, one can speculate that they got upset about Tesla playing hide the ball, right? And then so part of their argument is, well, that should not have been a legit reason for punitive damages. So that's sort of what they're arguing there. And we're going to see how that plays out. But that's been in the news since the trial that all that stuff has been going on. So we'll see. Stay tuned on that one, I guess. But from an engineering point of view, I sort of started with this, but let me come back to it. Now that we know all these things, if you want these vehicles to be safe in the future, and you have a person in there, and by the way, even on robotaxis, we've seen an injury mishap due to a remote operator commanding a robotaxi through a red light telling it the light was green. It wasn't strictly speaking a command. It's subtle, it's nuanced, but we've seen a robotaxi crash that was contributed to by remote operators. So there are no perfectly autonomous vehicles anywhere. They all have a human involved somehow, and it's a matter of. I have a blog post called "All Robotaxis Have Drivers," right? And it's a question of degree, not of kind. There's always a person in there who, if they make a mistake, can cause a crash. So this isn't going away for the next 20 years. And that is, what's the role of the human in safety? And it ranges from you're supposed to have your eyes plastered to the road with a death grip on the steering wheel 100% of the time, all the way up to the robotaxi phone's home, but you better not lie to it or it could be a safety problem. So in this case, what we had was, well, in general, there's a concept of operations, a ConOps, and part of the concept of operations is what's the role of the human in safety? Where on that spectrum are they? And here, the ConOps for Tesla was the driver's always paying real attention in the car may make mistakes and he's expected to compensate. And the driver wasn't fulfilling the ConOps. Well, that's why we have driver monitors. And so the question is, well, if you care about safety, you should not take more credit for driver attention than your driver monitor enforces. So we had a driver monitoring system that did not enforce the required amount of attention. That's how, as a safety engineer, I would look at it, right?
Yeah, I'm gonna ask you to repeat that because I think that's such a fundamental issue in this trial,
Sure thing.
but then in general.
Yeah.
Uh, but could you relate it to this trial?
So for this trial, we had a driver monitoring system that was happy to keep Autopilot engaged, even though the driver was staring down into the footwell. And a good driver monitoring system, if you want a safe outcome, if safety is what you want, then the driver monitoring system should not tolerate driver inattention. So it didn't beep because the driver was looking away. It beeped because it was about to crash. It should have aggressively beeped and threatened disengagement with a special acoustic alarm saying, "You're on your own, buddy." Not look at the center console and see what I want to tell you, if it's your windshield wiper fluid or whatever it is, right? Like, dude, Autopilot just went away. You better pay attention. Within I'm going to say 1 second after looking away from the road, because glances of longer than 1 second, there's some time, there's some formula, but we've seen other Teslas where they went from Tesla Autopilot turned on to fatality in 10 seconds. So the number's less than 10 seconds, and it should be more like 1 or 2 seconds. You look away from the road for a very short time, and it's like, hey, dude, I'm out of here, and not in a way that can be ignored. Not first chance, second chance, third chance, fifth chance. It's like, no, really, you got to pay attention. And that didn't happen. And that really contributed to this crash.
And the other part of this, the expert testimony, the human dynamic, the machine dynamic, and safety is something that Missy Cummings addressed. And I'm going to read a quote from her from this trial. It is my professional opinion that Tesla's Autopilot is defective because Tesla knowingly allows the car to be operated in operation domains for which it is explicitly not designed for. Now, you talked about ODDs before.
That's the other half.
About that, that's
the other half. Operational design domain is the manufacturer's model of the world it's supposed to drive in. Right. I said that very carefully. That's a whole different talk about why I said it so carefully. But when you're building the car, you say, well, we're designing this car to work, and in Autopilot's case of that era, we're designing it to work on limited access highways with no cross traffic and no intersections and no stoplights and none of that. And here it was allowing itself to be used on a road that had not just an intersection, but a T, right? And you can read the manual. It can say, well, watch out for roads with intersections. Not everyone reads the manual, but more importantly, human nature is we don't, some people have read all the manual for their car, not many, right? And some people have read all the boilerplate for the legal agreements, even fewer, right? How do we learn how systems work? There's a reason there's quick start guides, because and you have to buy the manual separately or download it because most people don't want to take the time, and that's human nature. So how do we learn? We learn by, well, let's see what it does, and if it lets me do it, it's probably safe. And so you learn it. The system teaches you what's safe by refusing to engage sometimes, which Teslas do. They'll refuse to engage sometimes, but allowing themselves to be engaged at the time. So a reasonable human response is, well, let me turn it on, must be safe. And the problem with this is Teslas let themselves be turned on roads that they're not designed to operate on. And that was part of the NTSB finding, and that was part of the NHTSA recall. It's a known problem with Teslas that they allow themselves to be abused in ways that a normal person would find, well, they don't even know it's abuse. It's like, well, it let itself be turned on. What? Should be fine. They kept saying, tell me how safe it was. If it were safe, it wouldn't let me turn it on if it can't be turned on, so it must be okay.
And I've heard Tesla take the position that, and other car makers take the position that you as the driver are responsible to operate the car safely. That general disclaimer, and that's not really the law.
It's not
And
the law. It's not how people work. And if you read the manuals, they're very vague. It amounts to let's blame the person when there's a crash.
yeah,
So there'll be limitations that you can't get out of the manual.
yeah, the
Uh,
National Highway Transportation Safety Administration has said human beings should remain alert and ready to take over, but it doesn't say you're at fault. And
yeah,
so if there's wording in
which
these
is the
manuals,
difference. Which is a difference. So,
it's
and
a huge
again,
difference. Yeah.
again, if you want safety, if safety is what you care about instead of just blaming others so you get off the hook, what you care about is the driver is alert enough to notice things they have to notice, and their mental state is they understand what they're supposed to notice. And there's some really tricky, my book goes into this, there's some really tricky, subtle things that go into this. It's a hard problem to solve. And what we've seen with this crash and many other Tesla crashes is Tesla has not really been going at this. They're happy to let drivers, uh, take shortcuts on safety, and their enforcement is very lax. Now, people who say personal responsibility, well, you should be personally responsible. You have to have the information to be aware to do that. But also, the people outside the car, the victims in this case, didn't get a vote on that.
And the worst, the foreseeable problem here is, and then we're going to get to some
Time for
questions.
Q&A. Yep.
Yeah. But the foreseeable problem here is that these cars are going to become more robot driven. Human beings are going to be more detached from what's actually going on or not understand the dynamics.
And
That's
not just for Tesla. I mean, we saw a BYD crash in, or no, sorry, it was a Xiaomi crash in China that really caused big changes in regulations there. So this isn't about Tesla going forward. This is about these are what all the cars are going to look like unless the companies and some are better than others, but the companies have to be really responsible at understanding the limits of human performance in these systems and design for safety instead of design for blaming drivers.
yeah. And as we get further down that road, this is going to be a problem that continues to grow. Hey, Tracy, thanks for showing up. What do we got in the Q&A so far?
Yeah, we've got several questions that came in. So let's start with this one, guys. Would it be helpful in determining liability going forward if the owner or leasee of the vehicle owns all data generated by that vehicle?
Since we're talking about ownership and that's a legal issue, I'll address this, but I'm sure Phil has some views on this. I think all the data in the vehicle is owned by the consumers. And
But the
but
catch is
ownership,
getting at it. The catch is getting at it, right?
right?
That's the
And
hard
so,
part.
but ownership of data is a really tricky concept. And so who has access to the data is the more important question. And yes, the owner of the vehicle, the person who was occupying the vehicle that may have been driving it, even third parties, I think they should have access to that data. Now, why should if an injured party that is not in my family and is somebody I hurt, should they have access to the data? There's no court in the world that's not going to allow discovery into the data in that car. There's a first principle thinking here. Data is in the car that is relevant to what happened in the accident. Now, you have to balance that out against who owns proprietary interest in that data. How's it organized? How's it used after it's generated? And I could see car manufacturers saying, no, that stuff's ours. How we take it and make our secret sauce, that's ours. But data about a crash, at the very least, owners should have access to it. And I think people that are involved in accidents where this data is collected, and as I said earlier, it's all being collected on newer cars, should have access to that data. And Phil, I don't know if you have any views on that.
Yeah, there's a specific game that's been played for years in various forms, which is it costs money If you're in a crash and you think it's the car's fault instead of yours, or even if you just think that autopilot or some other automation feature was turned on and may have contributed, the first question you have is, was autopilot turned on? I need to know. And what we've seen is that companies make it as expensive as possible to even figure out if that's true. Because they're just trying to raise the strategy is, and in a particular case, I can't speak on specifically, but the general strategy is the more expensive it is to ask the question, the fewer people are going to ask it and the fewer lawsuits they have to defend. So the controlled information partly is defended based on, well, it's trade secrets. But knowing whether autopilot was turned on in the 30 seconds before your crash is relevant to, is a lawyer going to invest time and resources even investigating the case? Now, something specific about Tesla is they have demanded redaction of all the data from all the crash reports they send to NHTSA, unique among the companies. The other companies don't do this. So if you're in a Tesla crash, there is no way for you to find out whether autopilot was turned on other than hire a lawyer and go digging. Now, I know more recently drivers have access to their logs, but I've also had numerous lawyers call me and say, what do I do? And I say, well, do you have the data? And they said, no. And I said, well, you're going to have to spend time and effort getting the data from Tesla to even know if you have a case. So there's a general principle that in legal wranglings of making it expensive for the other side to proceed, and access to data certainly plays a role in that.
Yeah, and I would say just wrap it up this way. Data transparency is going to be incredibly important for working on safety-related issues.
Yeah.
All right, how about this one? Digital forensics played a major role with experts recovering previously unavailable autopilot ECU data. How does this change the conversation about transparency and access to vehicle data in crash investigations?
Phil, do you want to take them?
Sure. From a technical point of view, what's interesting about this case is that Tesla got caught saying things that weren't true. Now, intent and motivation and whether they just didn't understand, not going to address. But they had the data, they said they didn't. And motivation is a whole different question. So now, anytime they tell someone else they don't have the data, you have to ask the question, well, did they really not have the data, or did they just lose it, or they delete it, or what's going on here? And so that increases the incentive to go looking in the car instead of just believing whatever Tesla sends you or Tesla says. Now, we noted previously that what you get sent is less than all the data that's in the car. So this has always been an issue. But until now, I know Mike in his data analysis business, every time I talk to him, he's like, well, we're just going to assume that Tesla's sending us what matters. Now you sort of have to revisit that assumption, based on Tesla getting caught not providing data that was actually available. Again, intent and how it happened is sort of a separate issue. But going forward, you can no longer just assume that because they said they don't have it means they don't have it.
Yeah, I just want to check on that one point. And what Phil's referring to is I and some colleagues built a company called Quantum Risk, and we take data from vehicles and show it to others. And we're not saying the data is accurate, and we're not working on the assumption that it's accurate. We're just saying, here's what the car manufacturer has provided, and you can draw your own conclusions as to whether or not it's accurate. But
and until now, when I talk to Mike, it's like, well, Mike, how do you know it's real data, right? And the answer is we don't, but it's, if we want to proceed in good faith, we're going to assume it is. And now after this trial, you have to start asking, well, should we really make that assumption?
Yeah. And the other part, it's important to note, though, that in this trial, Tesla wasn't accused nor was it proven that Tesla manufactured data.
Mm-hmm.
It's more a question of locating the data and providing the data and producing the data and talking about whether it existed or not.
Yeah, that's correct.
Tracy, what's in our next question?
I think this is a good one for you, Mike. From an insurance and mobility standpoint, what does this verdict mean for underwriting, claims handling, and risk assessment around automated vehicle technologies?
Well, it's interesting. One of the things in Tesla's post-trial motions was, listen, if you let this $242 million verdict stand, you're going to really chill um, the automotive world's interest in making cars safer and putting
Which is
new advanced
ridiculous, which
technology.
is ridiculous, but I'll let
But,
Mike continue.
but,
I just
but,
couldn't hold myself. That's ridiculous. Go ahead, Mike, and then I'll chime in.
but here's what's going on. These cars have been introduced into the wild, as engineers would say. It's being used, not just by Tesla, by
Beta software. That version, that car was beta software. Yep.
yeah, Tesla likes to call it beta software.
Yeah.
Uh, but you you now have data, and the cars are using new equipment. And when the accident happens, by and large, the car manufacturers, I've never heard one say, our fault. Car manufacturers say, humans' fault. So
Or sometimes they settle quietly, and it's not unreasonable to infer maybe it was their fault when they settle. Yeah.
sure. So, but you now have a situation where insurance companies are going to be looking at car accidents and they're going to have to start to evaluate how do we apportion fault to a car where traditionally that's never been done before. And insurers, as when the car manufacturers say not our fault, they're getting a free benefit from the insurance industry. So automakers have been putting this new technology out there. They're developing it on the go. They are using human beings as test pilots, and then the consequences, not our problem. The insurance industry unwittingly has been bearing the risk of development.
Yeah. Well, and so this is something you can weigh in too, but I've never heard of a case where there were a bunch of crashes, insurance companies paid out. Later on, it turned out there was a design defect. And did the insurance companies go back? I mean, did the insurance companies sue General Motors for the defective ignition switch issue? I mean, does that ever come home to roost?
I saw it, if you remember, and Phil, you and I are both old enough to remember the 521 tires by Firestone.
I had two of them try and explode on me. So yes, I do remember those.
Yeah, I think there was some class action litigations
Yeah, yeah,
where at some point it wasn't an insurance company who started them, but they ended up being involved because they had the accidents.
yeah.
But we're talking about ancient history now and a much different kind of technology. The um, but I would say up until now, the insurance industry sue a car manufacturer,
Right.
like that's hard.
Well, and
That's
it in the
expensive.
scheme of things, it's not that much money. It's just not worth going down the hole. But I think what we're going to see is the right now, if you want to sue a car manufacturer, you're talking product liability, which has all these issues, right? And I think necessarily, okay, I'm on my soapbox. Everyone knows I'm on my soapbox. Necessarily, what you're going to see, Bill Wyden and I have written all these papers that there's going to be shift to negligence tort for our car crashes that involve automation. And as if you see that happen, which is the only way the court system doesn't collapse under product liability caseload, the only way you see that happen is if a car manufacturer can be sued for negligent tort. And now you're into, well, yeah, the insurance companies do want to blame a car. And so that's the mechanism that'll happen. This is coming. If you're an insurance company, you're going to have to decide how to blame car manufacturers. And that is very much unsettled now, but it's going to happen. It will happen. It's inevitable. It's a question of how fast and how big.
Well, we're at 128. Do you guys want to take one more question?
Yeah, let's take one more.
Okay. We have here Tesla rejected $60 million in settlement proposals before the trial. What do you think this reveals about Tesla's litigation posture, and what lessons should insurers and manufacturers take from that decision?
Yeah, well, people have to understand what's at play when that happens. So plaintiffs or defendants can say to the other side, here's how much money I'm willing to pay now. It's not so much they think the case is worth that, but they're trying to think of almost as table stakes. So I'm going to say I'm offering to settle this for 60 million. If you reject that, then you're going to be responsible for other things like attorney's fees and cost and that sort of thing. And it's usually referred to as an offer of judgment. So that's what that $60 million offer was. But Tesla could have accepted it and not gone to trial.
There's another point that's underreported, which is Tesla offered them a settlement before that. So Tesla offered them a number we don't know. And they responded by saying, I don't think so. The number is 60 million. And Tesla said no. So when
Yeah.
people say, well, Tesla would never offer to settle if they weren't at fault, Tesla offered to settle, right? That
Yeah,
was
but
that was reported on, but not 60 million.
Tesla may have played the same
Yeah.
card in reverse, though. They may have said, "Hey, we're willing to settle for 15 million
Well,
because
that's a number you made up, to be clear, but yeah, a number.
yeah." And so we don't know what that offer to settle was, and
Yeah.
there's differences between. Generally, offers are not admissible ever, except in these kind of scenarios. So there's offers and there's offers of judgment, and they're
So
really
Tesla
two
said
different things.
some number we don't know. Plaintiff said, no, I don't think so. How about 60 million? Tesla said no. And now maybe they're regretting that decision.
Well, I'm sure they're thinking 60 is better than 250. Wish we
Right.
could go back. So
Yeah,
anyway,
that's pretty straightforward math. Yep.
but let's put a pin in it for today, Phil. And I want to thank the audience for great questions. And Tracy, thank you very much for helping. And Phil, you as always are the smartest guy in the room, as I always say about you. So
Well, great conversation, Mike. Thanks. It's a great to team up with an actual lawyer and get to play the techie. So thanks.
And we're going to say goodbye to everybody, but look for more of these, and definitely at least one more with Phil and I talking a little bit more generally about this growing dynamic of technology on the road and how we're going to deal with this as a society. So appreciate your attention, and I can say that another person that Phil knows very well, Brian Reamer, has agreed to be a guest of ours in the future.
Great.
And we're going to be talking specifically about accessibility of data in cars. So stay tuned for that announcement on when we're going to be doing that webinar. Thanks a lot, guys.
Thanks.